dimension. And so our first speaker will be Professor Simona GHERGHINA from this university.
Thank you. I'm not sure I'm using the presentation, as nobody has, but I believe that the starting point of any discussion on the balanced budget rule and the vertical and its impact on the vertical separation of powers should start from the distribution of financial powers between the central government and the local authorities. And I'm trying to use general terms that will be able to cover all existing types of state organization, from federal states to regional states and unitary decentralized states. So in any case, the problem will be how this separation of financial powers, of financial resources, and the power to administrate such resources will be made. First, this separation of financial resources starts for sure from the limited nature of resources. So they are limited in nature, so they have to be split between the central government and the local authorities. And the question is such split provided by the Constitution, or is it provided by laws, by ordinary laws? This will be a question. The second issue related to the distribution of financial powers between the central government and the local authorities relates this time to a fully constitutional principle, which is the local autonomy, the local self-government. So at this point, local autonomy would mean that having their own resources, the local authorities will have the ability to manage them, to decide on their management, but also will include a limitation, a state interest in the limitation of local borrowing, because the state would fear to be seen implicitly as the guarantor for the debt of the local authorities, despite the fact that most constitution or national regulations include a no bailout clause. So in most national legal system, the rule is that the principle is that the state is not liable for the obligation for the debt of the local authorities, but still, when local authorities are borrowing, behind them, the implicit shadow of the state is seen. So probably the borrowers somehow believe, the lenders, sorry, somehow believe that the state will ultimately pay these debts. So the local autonomy would mean that the local authorities will have access to sufficient resources, and given the usual limitation of their ability to borrow, they will be able to manage such resources in a way that will not leave them at any point in time in the situation to not be able to have access to resources needed to cover their charges, their expenditure. So from this point of view, we have the states which have ratified the European Charter of Local Self-Government, which have accepted the principle stated in the Charter that the local authorities shall be entitled to adequate financial resources of their own, of which they may dispose freely, and also that such resources have to be of a nature that is subject to the decision of the local authorities, which means that the financial resources will include taxes whose rate may be determined by the local authorities, so they can control the resources from tax. And also that when they receive grants from the state in a certain modality that we'll analyze later, such grants generally should not be earmarked for a specific project. So again, the decision on the use of funds will not be on the central government, but rather on the local level. So from this perspective, local autonomy has an important element of financial autonomy, which we may deem to include the fiscal autonomy, the possibility to either receive taxes, to either collect taxes for which they may determine the rate, or to be entitled by law to receive redistribution of taxes which are collected by the central government. So in this point, the larger the fiscal resources allowed by the law to be collected directly or which are automatically distributed by the central government to the local authorities, the larger the fiscal autonomy, and of course the larger the financial resources available to the local authorities, and presumably the fuller the local autonomy and the financial component of the local autonomy. Second, the second component of the financial local autonomy would be the budgetary autonomy, their power to approve their own budget, and of course allocating to certain expenditure the resources which are available according to the law. And third, the autonomy on the management of the funds, meaning that they will be free to determine their own type of expenditure which are fit for the needs of the local community. Of course, here we may start a discussion on the fact that at any local level, as of course as in the central level, of course, there is a specific and significant place for what we may call mandatory charges, mandatory expenditure, which cannot be completely removed from the budget, not also can be reduced freely by the local authorities. So the local autonomy of the local autonomy will include, at the end of the day, a financial component which, due to the limitation of resources, may bring us to the idea of an implicit balanced budget rule existing at the local level. Because if your resources are limited, if your power to collect from taxes is limited also, and you are subjected to the obligation as a local authority to undertake certain mandatory expenditures for the local community, then all you can do is, and also you have a limited access to borrowing, then all you can do is to try to stick your expenditure to the existing resources. So then you have the balanced budget rule, which may seem to be implicit at the local level. For this reason, we may see that in several countries, the local budgets already are split in a functioning section, which will include the expenditure, the current expenditure needed for the proper functioning and exercise of the local powers of the local authorities, and also an investment section of the budget, whereby are located the investment expenditure. So if you are not able to cover your current expenditure in the functioning section, you will not be able to spend on investment. Again, this is linked to the general rule that we will see in most regulations, in most national systems, that the local borrowing, also being limited as an amount, is also limited in destination, because in the local authorities, they only may borrow to finance the investments. Here, there is a difference between between the national systems, because most of them will apply what we may call the principle of neutralizing of loans, which means that the local authority cannot borrow for refinancing its existing loans, but other states like Romania, for example, do not accept this principle. So local authorities in Romania may borrow for financing their investment, the local investment, but also for repayment of the existing loan, for refinancing of existing loan, which is a power granted by law that may be debated further. Another component, and the major component, which bring us back to the discussion on the asymmetric allocation of resources and the distribution of financial powers between the central government and the local authorities, is the issue of transfers provided by law to be made from the central budget to the local budgets, because these transfers are practically, in most cases, they give most of the resources of local budgets. So when the local autonomy is based on the financial resources coming mostly from transfers from the state budget, we are in the position to ask ourselves if this is not a problem, or this reality is not somehow able to affect the local autonomy. Because if such redistribution of income, of national resources from the central budget to the local budget is not made according to objective and reasonable criteria, then the local autonomy just remains a nice principle, but without any reality. And here it is the question that arises also, has the rules applicable to such transfer, they need to be included in the Constitution to give effect to the local autonomy? Because otherwise you may have a situation whereby, for example, in Romania, you have several types of transfers applicable from the central budget to the local budget. Some of them are automatic, so it's just a matter of calculation of the amount to be transferred. Here we speak about redistribution of income tax and a certain redistribution of VAT. But also you have some types of transfers which are of a more subjective substance, which means that is for the government to decide to whom they transfer the amount, basically which local or community is in need of those resources. So the lack of objective criteria may lead to a political distribution of resources, which is a direct attempt, at least in my opinion, to the local autonomy. So other than the fiscal equalization, which is seen as an automatic redistribution of taxes, you may have financing of national programs made, which happen at the local level, but which is made from the central budget. And here, okay, you have a national interest for example, in Romania, health programs, national health programs provide for transfers of funds from the central budget to the local budget. Also, development funds are transferred for local investments. But again, this direction of funds from the state to the local budgets is somehow against the principle stated, or the principle upholding the local autonomy as stated in the European Charter of Local Self-Government, which says that normally the funds directed, the grants directed from the central budget should not be earmarked. So they should be granted to the local budget for them to decide how they use the funds. And third, another possibility to have transfer, and this is a general possibility to have transfers from the local, from the central budget to the local budget, is the compensation for additional powers granted by law to local authorities, and which is again covered by the European Charter for Local Self-Determination. But the effects of such transfers from the state to local budget may involve a role for the balanced budget rule. Again, at the local level, the fact that the budgets are balanced by these transfers is not likely to have a complete golden rule applicable, because then you will have the golden rule applied, but by affecting the local autonomy. And this is not the point. When you apply the balanced budget principle rule, it should not limit other principles. So when you have the local budget balanced, this is a good thing, but not in itself seen separately, but in conjunction with the principle of local autonomy. And again, at the national level, the existence of such transfers has an impact of the balancing of national budgets, because the national budgets are subjected to the limitations on deficit and debt, for example, for the European member states imposed by the European regulations and the Treaty on Stability. But as the transfers from the state budgets for the equilibration, for the equalization of local budgets are becoming more and more important, then you may have a problem in ensuring the balancing of the national budget. Again, some states are providing for rules allowing the transfer of funds between local budgets. Romania does not have such provisions, but Germany and France, they do have such provisions. And again, the problem arises in respect of criteria. And here you have two types of criteria: the criteria of collection, the funds that are to be redistributed, and also criteria for reallocation, for redistribution of such funds. In both cases, they have to be objective, because we get back to the idea of political decisions that will limit the local autonomy. Again, the balanced budget rule has a role here, because normally such a transfer between local budget may be justified only by the existence of mandatory charges that one local budget cannot cover, and therefore the national solidarity will be the basis, the principle allowing for the transfer of funds from a local budget to another local budget. Finally, there is a new type, the crisis brought about a new type of rules aiming to enforce balanced budget rule at the local level. And these may be qualified as legal obligations ensuring budgetary discipline, both at the central level, but here we will focus on those involving budgetary discipline at the local level. And such legal limitations which are applied to management of funds are created or were created for a specific case, which was the case of Romania. The case of overdue payments, payments which are very late compared to their due date. We call them arrears in the legislation, and the government undertook an obligation to the financial institutional financiers to reduce them. So the result were some laws which limited the ability of local authorities, which registered in their budget overdue payments, to sign contracts, to sign new contracts. So you are not allowed to sign any new contracts if you have overdue payments. You are not allowed to make payments at all in existing obligations. If you have overdue payments, you are only allowed to pay salaries of the budget personnel, of the local authorities personnel, and also to pay the overdues, of course. And again, you are not allowed to undertake any loans as a local authority. And there are also regulated special procedures for recovery of financial crisis, and even an insolvency procedure for local authorities. So again, another possibility, and this is the final issue I'm reviewing, another possibility of transfer from the central budget to the local budget and financial assistance from the state to the local budget, which may again impact on the local autonomy, are the loans that are made available by the state to the local authorities. The local authorities may borrow from the state money for treasury purposes, so to cover the temporary deficit of funds in execution. They may borrow for specific projects, and these are usually sub-loans. And then they may borrow to pay their debts. And all these loans are guaranteed with the redistributed taxes. So if you borrow money from the government as a local authority, you guarantee such loans with the right you have as a local authority to receive the redistribution of taxes from the central government. So they may exist also explicit state guarantees for local loans, and this is again no objective criteria for granting or not such guarantees, such state guarantees. So you may have local authorities receiving state guarantees and thus being able to borrow money, and other local authorities which are not receiving such guarantees, so they cannot borrow money if they want. To conclude this intervention, I would say that the Constitution would be a good idea to include in a Constitution the lines, the general lines at least, or principles of separation of financial powers between the central state, the central government, and the local authorities. Of course, I think that behind all these rules, there will be the balanced budget rule, which will in fact justify them. Thank you so much for your attention.